more what didn't happen. Okay, Shannon, you can put us on.
Okay.
Okay, we're back on Gibson versus M&M Core to address the supplemental briefs and provide opportunity for additional argument. I have thoroughly reviewed both of your briefs, but if there's anything you'd like to add, I will give you that opportunity. I don't know which of you wishes to make the argument.
Sure. I mean, Your Honor, it's our motion for summary, so I can go first. Again, I won't rehash what was put in my brief, but just to address a couple of things in my sister counsel's brief. My main concern is that she appears to be using her own definition of what an ambiguity is, rather than what Michigan law defines as an ambiguity. And Michigan law states that a contract is ambiguous when it is facially inconsistent with its own language or can reasonably be interpreted in two or more ways. And in this case, there's nothing about the price that they're claiming is ambiguous. There's nothing about the vehicles that they're arguing is ambiguous in the briefs. Rather, the two terms or two phrases that they argue create an ambiguity are the disclaimers: we will not be responsible for contamination cleanup, and we will not remove boats or motorhomes, as that contemplates some form of cleanup. And from the outset, I would say, first of all, that doesn't contemplate any form of cleanup. It's a disclaimer. My client is a scrap metal buying business. In removing particular things like old used vehicles that could have petroleum leaks or things like that, there can be soil contamination in removing scrap metal. It's just a standard disclaimer in the industry saying we're only buying the metal. We're not going to be doing any sort of contamination cleanup. And so it's very twisted and tortured logic to say a reference to that disclaimer can somehow have the alternate reasonable interpretation of meaning, well, we actually agreed to put the property in broom clean condition. And that's the legal standard. It has to be reasonably interpreted that way. That particular phrase that they're claiming is ambiguous. And if that logic or line of arguments would be followed, then contracts would frankly be completely worthless, because any sort of disclaimer would say, well, look, you didn't disclaim this particular thing, so you must have contemplated it in your agreement. And that's not a reasonable alternate interpretation. It's the exact opposite. It's a brand new affirmative duty, because the only duty placed on my client in the contract is pay this price. Pay this price in exchange for these vehicles. So we have to look at the plain terms of the contract. And a few other points I'd like to touch on in my sister counsel's brief. They claim the GMC case is not similar because in that case, the court found there was no ambiguity in the contract. And for the reasons I just submitted, Your Honor, I'd say that's the exact same case here. There's no ambiguity in the contract. The terms that they've pointed to simply cannot be twisted in the way that they want to have any sort of alternate meaning. It's in fact an opposite meaning that they're trying to bring into the contract. And they say right in their brief, the contract is silent on some types of cleanup and removal. That's because cleanup and removal was not part of this contract. It was purchasing metals in exchange for a price. And that's the only obligation imposed. They indicated that because the parties were not sophisticated at the end of the day, they shouldn't be held to a higher standard. And, that kind of made me chuckle, because I'd like to make the same argument with my client relative to a merger clause or integration, because, boy, that would be nice to have that in this case. But, at the end of the day, we don't. But it doesn't matter because there's no ambiguities that can be interpreted that way. They also indicated in their brief that the UCC did not apply because if the contract contains any provision relating to a service, then the UCC doesn't apply. And again, that's incorrect on its face per the Supreme Court holding in GMC. GMC case did contain provisions relating to a service, the upfitting for purposes of market segmentation. They say there was no benefit to GMC, or that didn't form any sort of consideration or value to GMC. And the court clearly held that it did. It's modifying vehicles. It was a future service in exchange for a vehicle discount, so that the market wasn't flooded with all vehicles of the same specs. GMC clearly got a value in that, and the court said, look, if this discount or this value in exchange for that was so pivotal or so essential, then it should have been included in the contractual terms as part of the discount. And then finally, regarding some of the case law cited in her brief, she claims that Michigan courts do not follow Illumi Bunk anymore. And again, that's inaccurate. Illumi Bunk has never been overruled or anything like that. It remains good law to this day. It's a Supreme Court opinion. The cases cited by counsel don't reference or cite to Illumi Bunk at all. In fact, they're really factually not analogous at all. The Titan Insurance case had to do with an insurance policy and fraud in the inducement. It wasn't a contract for the sale of goods with a supposed discount for future service. That was the case in GMC. That's supposedly the case here. And similar to the other two cases cited, the Migliazzo unpublished one and the Rahim versus Denton unpublished one, those were both sales of houses. No future services pled in that. And so to say, well, look, this intertwined theory wasn't brought up in this case, that's because it didn't apply. Those were factually distinguishable cases, and I think that GMC remains good law and is clearly relevant to the situation. So at the end of the day, Mr. Gibson signed a contract which set out a price. It set out the number of vehicles for scrap metal that would be purchased, and it had a disclaimer that there would be no contamination cleanup. Those were the terms, and there's no ambiguities in there per the legal definition of what an ambiguity is under Michigan law. If the supposed discount, Mr. Gibson has attested in his affidavit, that was the sole reason he set this price, was because of an obligation to put the property in room clean condition. If that was so central, it should have been in the contract. Parties are presumed to understand and have read contracts they signed. And in this case, Mr. Gibson signed a contract that clearly contained no references to any sort of room clean condition or obligations other than pay this price, no reference to a discount. And so at the end of the day, Your Honor, I think that decides it. I think that the GMC case is on point. So that was all I had relative to some of the arguments brought up in my sister's brief. Happy to answer any questions the court may have of me, but that's all I have for now.
So do you agree that the GMC case has no application to the counts in the complaint that alleged that your client took vehicles he wasn't supposed to, damaged some vehicles, took a boat that he wasn't supposed to, etc.?
Yeah.
Things that weren't in the contract.
Those things that are extraneous to the contract, I agree, because GMC doesn't stand for those propositions or wouldn't address some of the things relative to property damage or conversion or things like that.
Thank you. Ms. Smith?
Your Honor, I think the one of the last sentences in the GMC case, I think, to me, shows that these two cases are not similar at all. It says the language of the agreement is, and this is a quote from it, straightforward, unambiguous, and clearly falls within the scope of the UCC. So that was the contract that they were looking at in GMC, to make their decision based off of. And that's just not the case here. We have this 4-sentence contract, and 2 of the sentences allude to cleanup and removal of items. So to me, when you look at the language of the contract, you look at the plaintiff's affidavit, you look at the site video, I think when you put all those facts together, it's clear that there is an ambiguity there that needs to be flushed out by the jury, not to be dismissed on summary disposition. I mean, why would defendant put language in?
Let me stop you for a minute.
Okay.
What is ambiguous about the language, "We will not be responsible to remove any boats or motorhomes"? Where's the ambiguity there?
saying we're not responsible to remove some things leads to the question of, well, what are you responsible to remove? It was sort of in other words, the plaintiff believed that they were going to remove everything except those things that were put in the contract. And as far as cleanup, the same argument goes.
270 vehicles, 2 loaders, 65 engine cores, forklifts, car hoists, air compressors, and small parts. See attachment A. We will not be responsible to remove any boats or motorhomes. Well, I don't see any ambiguity there. They're certainly responsible to remove the things they purchased. And here we've got boats or motorhomes excluded from the purchase. So let's look at the second sentence. We will also not be responsible for contamination cleanup. What is ambiguous about that? It seems pretty clear to me. I don't think it's capable of more than one interpretation.
Your Honor, I think it begs the question, if they're not responsible for one type of cleanup, why even put that in there if they weren't responsible for other types of cleanup? It begs the question of why are these two sentences even in there if they weren't supposed to remove other things and clean up other things? They would be completely irrelevant and unneeded if all they were doing was selling vehicles from the plaintiff to the defendant. If that's all that was going on here, all you would need is the first two sentences. You wouldn't need any other language in this contract. And when you look at that language combined with what the plaintiff alleges was the contract in his affidavit, and when you look at the site video where the defendant comes in and says, yeah, we're going to get rid of this and we're going to take that and we're going to do this and do that, why would the defendant have even come to the site visit video if he didn't have a responsibility to remove other things and clean up other things? And why would he have agreed in the site visit to even do those things? I think when you put all that together, that's where you see the ambiguity. Maybe not. And I think really the site visit video is really integral to understanding what was going on in this transaction and, the statements that were made by the defendant at that site visit.
Do you have any other argument you want to present today?
Well, yeah, I do. The defendant says that I don't seem to understand what an ambiguity is, but when you have a choice between two more possible meanings, then you have to look at the circumstances surrounding the making of the contract. And when you do that, you look at the affidavit, you look at the site visit video, I think you see that there is indeed an ambiguity here. And as far as the GMC case, there was no ambiguity in that case. There was no mention whatsoever in their contract, which was drafted by the party who filed the lawsuit. There was no mention of upfitting whatsoever. And upfitting, to me, is not a service that's being provided to GMC. GMC sold these vehicles to Illumibunk. Then Illumibunk owns them. They make modifications to their own vehicles. I don't see any aspect of service in that. So that would fall under the UCC. But in this case, the plaintiff alleges that he was to receive a service, which was the cleanup of his property and removal of items from the salvage yard. So in that way, these two cases are not similar at all either. And I still stick with my argument that I don't believe that the courts are following this theory of intertwining facts which negate other causes of action, that you can only have a breach of contract action and you can't also have fraud actions if they're all based on the same facts. I didn't see any support for that theory in any of the other cases that I looked at.
Did you find any other case that involved the UCC where they disregarded the GMC case and the economic loss rule? The economic loss rule only applies to UCC cases. It doesn't apply outside of that. So it's not surprising to me that your unpublished cases that deal with the sale of a home or the other opinion that dealt with insurance contract, the UCC isn't implicated in any of those cases. The only reason the Supreme Court in the GMC case said that the tort claims are intertwined with the contract is because it's a UCC case, and under the UCC, the economic loss rule bars those tort claims.
Well, Your Honor, I don't believe that our present case falls under the UCC at all, because there is an allegation of an element of service that I think when you look at all the facts put together, you can see that the plaintiff's assertion that he was supposed to receive a service, in other words, the cleanup of the property and removal of items, was part of that contract. I mean, to read it any other way would make those the two last sentences completely unnecessary. But they are in there, and they were put in there by the party that drafted it, which was the defendant. So they obviously have some meaning. And this argument that that's a disclaimer, this is the first time you've ever heard that, Your Honor. That's never been put in any other brief that they filed with the court. So this is something totally new.
All right. Thank you, counsel.
You're welcome, Your Honor.
I appreciate your thorough briefing of the GMC case. I frankly agree with the defendants. I think the GMC case acts as a complete bar to the breach of contract claim and to the intertwined tort claims. On every point, the GMC case is squarely on point with this situation we have here. Yes, there's two sentences at the end of this very short agreement, but they're not ambiguous. They're not capable of more than one meaning, which is what ambiguous means. Is this phrase, are these words capable of more than one meaning? They're not. They're very clear, and there's good reason from a practical standpoint of why somebody who's removing scrap vehicles from someone else's property would be concerned about obligation to clean it up. If you're going to be picking up cars, moving them onto, and I don't know if they crushed them first or not, but however they transported these vehicles, when you're picking them up and putting them on a trailer, there's certainly a risk that oil, coolant, whatever is going to spill from that onto the ground. It makes perfect sense, wholly apart from your argument that well, this means there really was an obligation to clean up the property. It makes perfect, unambiguous sense that if we spill any fluids in the process, it's not our obligation to clean them up. We're not obligated to do that. Similarly, the provision that says we're not responsible to remove motorhome or boats or whatever, I think that was the language, simply makes clear those aren't part of the deal. They're not ambiguous. They're not capable of more than one meaning, which is how you define an ambiguity. I think the GMC case is on all fours with this one. It compels that I grant the motion for summary disposition as to the breach of contract claim and as to the intertwined tort theories. What remains are the claims of conversion and relating to, and also, excuse me, the claims that property was taken or damaged in the process of removing those will remain. I am also, Ms. Smith, going to grant your motion to withdraw. We put that over to give you the opportunity today to argue this issue that you were involved in. I want, Mr. Gibson, have you had a chance to arrange alternate counsel yet?
No, I wanted to see how we came out today, but I have talked to Corey and possibly Mr. White, but I will arrange for a different counsel. Thank you, Your Honor.
All right. So, Ms. Smith, if you could provide in your order granting your motion to withdraw that Mr. Gibson has 30 days from entry of the order to arrange for substitute counsel. And if he needs additional time, he can simply ask for it. That part doesn't need to be in the order. I just want him to understand that. But 30 days should be sufficient, but if he runs into a snag, I don't want him to be in any way prejudiced by the change in council.
Thank you.
Okay, certainly, Your Honor.
All right, I will await that order. Thank you all. Have a good day.
Thank you very much, Your Honor.
Have a good day.
I should ask, Your Honor, are you going to be issuing the order relative to the motion for summary? Do you want me to draft something under the 7-day rule?
Oh, you need to submit that.
Okay, all right, just wanted to clarify. Okay, I'll
Okay.
be sure to get something out.
All right, thank you.
Thank you very much, Your Honor.
And it looks like we got somebody here for a 10 o'clock.